Many of us knew that if Roe v. Wade was overturned and kicked back to the states, that women were going to die. And when these states started implementing these very restrictive abortion laws, experts were out there warning that women were going to die. And now ProPublica is reporting that we may have our very first confirmed case of somebody dying due to the restrictive abortion laws in Georgia. Her name was Amber Nicole Thurman. She was a 28-year-old medical assistant. She had dreams of going on to be a nurse, and she had a 6-year-old son. Now her son will be forced to grow up without a mother because of these draconian abortion bills in Georgia. Amber became pregnant shortly after the Georgia abortion ban took effect. So she had to travel out of state to get a surgical abortion. But because her travels were delayed, she had to settle for a medical abortion. She was only 9 weeks pregnant. It was a viable option at the time. She took the first pill, came back home. The next day, she took the second pill, and things only went downhill from there. She started cramping. She started bleeding heavily. So she returned to her local hospital where she found out that she had a rare complication from the medical abortion. And some of the fetal tissue wasn't fully discharged from her uterus. And she had an infection. And she became septic. And because these restrictive abortion bans are not clear on when treatment can be administered, and they are not clear about how close to death one must be for doctors to perform a surgical abortion procedure known as a DNC, the team involved waited nearly 20 hours before they decided she was close enough to death to get a DNC. But by then, it was too late. Her organs shut down. Her blood pressure collapsed. She was fully septic. And she ended up dying. Now, you might ask yourself, how is it possible that these laws are so unclear that the doctors, didn't feel comfortable moving forward? Well, I think we should listen to a doctor from Georgia talk about this very thing. Her name is Dr. Carrie Swiak. She recently testified at a John Ossoff subcommittee hearing about the effects of these abortion bans. And she lays it out pretty clearly that doctors and nurses are very confused by the laws that are on the books and how unworkable they are because they are so vague. Let's go ahead and take a look at what she had to say.
I have talked to many physicians throughout the state who are confused by the language in the law. In large part, this is due to new rules that don't fit the reality of what people experience in pregnancy and the harsh criminal penalties physicians face if a prosecutor, judge, or jury doesn't agree with their medical judgment. When is something an emergency? When is pregnancy futile? When do the exceptions apply?
These are all very complicated questions in the time of crisis. If Amber Thurman is coming to your emergency room with an infection due to a legal abortion that she had out of state, your laws should be able to address those types of scenarios, or at least be written in a way that the doctors have clear direction on what they can and cannot do. If you're going to ban abortion in the state, your law has to be clear. Or there will be times like this when women are unable to receive the care at the exact time they need it, and they will die, just like we have seen in Amber Thurman's case. Let's go ahead and listen to Dr. Swiak on the consequences of delaying care, which is such a huge deal now because doctors don't feel comfortable providing treatment until these patients are on the brink of death. And by that time, it's really going to be hard to prevent many of the consequences that follow. Let's go ahead and listen to her on that.
In Atlanta, physicians, myself included, have seen patients in the ICU with sepsis, with renal failure, needing tube feeds, with hemorrhage, needing blood transfusions or a hysterectomy, who would not have been in those positions if we had been able to offer them care to avoid further harm. It is the standard of care to offer a termination of pregnancy to patients experiencing a complication early in pregnancy because it is the safer option for them. These outcomes would not happen if their providers were able to practice medicine in an ethical and evidence-based manner. As physicians, we are trained to identify when a patient is at high risk so we can provide care to prevent them harm. If we need to wait until harm is already occurring, we're often too late to prevent the consequences.
She's exactly right. If you're having to delay care for hours and hours, there's going to be inevitable consequences of that you're not going to be able to combat because you've had to wait so long to administer care. And that's exactly what happened with Amber Thurman. She got a legal medical abortion out of state, had a very rare complication due to that medical abortion, and because the Georgia law is so vague, she wasn't able to receive the DNC when she showed up in the emergency room that day. So I wanted to take a look at the Georgia law because I think it's important that we actually read these things and see just how vague they are. And I think that this is a deliberate act by Republican lawmakers because when there has come an opportunity to add some clarity to these laws, it has not been done. Let's go ahead and take a look at the Georgia law, starting on line 88 here. It defines abortion as means the act of using, prescribing, or administering any instrument, substance, device, or other means with the purpose to terminate a pregnancy with knowledge that termination will, with reasonable likelihood, cause the death of an unborn child, provided, however, that any such act shall not be considered an abortion if the act is performed with the purpose of removing a dead unborn child caused by spontaneous abortion or removing an ectopic pregnancy. So let's just pause right there. How does Amber Thurman qualify for these two carve-outs here? She had a legal medical abortion out of state, so therefore she doesn't qualify for the spontaneous abortion, which would be like a natural miscarriage. And this wasn't an ectopic pregnancy. So how are the doctors supposed to know when they can administer care? These laws are too vague to the point of unworkability. Let's go ahead and keep on reading. Detectable human heartbeat means embryonic or fetal cardiac activity or the steady and repetitive rhythmic contraction of the heart within the gestational sac. Okay, so that's where they define heartbeat. Medical emergency means a condition in which an abortion is necessary in order to prevent the death of the pregnant woman or the substantial and irreversible physical impairment of a major bodily function of the pregnant woman. Okay? How close to death does the woman need to be before an abortion can be deemed okay? There is no clarity here. Let's keep reading. No such greater risk shall be deemed to exist if it is based on a diagnosis or claim of a mental or emotional condition of the pregnant woman, or that the pregnant woman will purposefully engage in conduct which she intends to result in her death or in substantial and irreversible physical impairment of a major bodily function. So basically saying if she's making threats of suicide or harm to herself, that those can't be considered. I think that's what that says. Medically futile means that in reasonable medical judgment, an unborn child has a profound and irremediable congenital or chromosomal anomaly that is incapable or incompatible with sustaining life after birth. What exactly does that mean? What if there is a severe genetic disorder that means the lungs aren't going to fully form before birth, but technically it's going to, suffocate to death after birth and maybe live for a couple hours? There's no clarity here. These laws are too vague. And there's so many different variables involved where, of course, doctors are going to be afraid to make the wrong decision. Because imagine the type of decision they're now having to consider. If they provide care for a woman like Amber Thurman, and a prosecutor wants to challenge the doctor's decision-making and take that in front of a jury that might not fully understand all of the variables involved or might not agree with the decision that was made, is the doctor going to be expected to put their license and their life on the line in the form of prison time? Is that really a reasonable request? Not to mention, these doctors, they're probably thinking to themselves, well, if I get locked up for 10 years, look at all those other women that I'm not going to be able to provide care for. It is a real catch-22. No decision is a good decision here. That's why these doctors and nurses are probably waiting until these patients are on the brink of death before they make the appropriate decision. Just in case somebody wanted to come up behind them and challenge their decision-making process. They want to be absolutely sure that their thought process would make sense to anybody. I think that sets up a really bad incentive structure. I don't even know if that is the proper terminology. But it pits the doctor's expertise against Georgia law. And as we're seeing here, that has very bad outcomes for the patients involved. Let's go ahead and listen to Dr. Swiak on how these laws have such a chilling effect on these doctors and nurses.
The law itself has a chilling effect because instead of being able to rely on guidelines of medical ethics, national guidelines, standard of care, evidence-based practices, we now have a law that threatens us with criminal prosecution if a prosecutor doesn't agree with our medical judgment in a circumstance. And what occurs is then physicians are unsure how to act while they're waiting for clarity. Then they may feel that they can't take care of a patient in a particular situation, or they may wait until they act in that situation. The other thing to think about is that it's not just the physician acting on their own. We provide this care within a hospital or within a clinic, with nurses, with anesthesiologists, and everyone has to decide that they feel comfortable with the interpretation of the law and that we can proceed in a certain situation.
I think that last point is so important to point out because it is something that I hadn't considered before. It's not just the doctor that has to make these decisions. I'm sure the doctor is working with 3 or 4 other people at any given time. And if they are involved in this patient's care, then everybody needs to agree on the same interpretation of the facts on the ground compared to the law in place. So now you have to come up with a consensus between, 2 to 5 people before you can even think about providing the necessary care? This is just going to have such terrible impacts on so many people. ProPublica figured this out because a committee that studies maternal death in Georgia was able to comb through these records, but they are on a 2-year lag. This happened right after Roe v. Wade was overturned, which means there are only more women out there that have died due to these draconian abortion laws. We have to be more thoughtful when we put these types of laws in place. These types of laws should not even exist, in my opinion. But if you are going to pass laws like this that are so unworkable, these are the outcomes that we can expect. It is just a damn shame that we now have women dying because of the Republicans down in Georgia. That is sickening to me. And the supposed pro-life party has now made it so a 6-year-old boy is growing up without his mother. And what are going to be the downstream impacts of that? I think that's all I got for you guys on this one. If you got anything out of this video, please do remember to smash that like button. Remember to hit subscribe. I'm only a budding new content creator that would very much like your support, trying to make it to that 1,000 mark. So I'd love your help in that. If you want to learn about how these abortion bans are impacting women all across the country, go ahead and watch that video on the screen now. Otherwise, I will see you guys on the next one.